question would be, we have this before us as part of a bigger picture, and that is we will be having a ballot question, and if, say, that's approved overwhelmingly, which doesn't matter if it's one vote more, but overwhelmingly is always, I guess, a good thing. Does that affect us at all? And if it doesn't have any effect with what we're dealing with, then, you know, that question's moot. But if that were the case, just keep tabling until the election's over, or table it till it's over with.
Commissioners, are we doing? Commissioners?
Again, I'm asking staff, I'm asking Brian or John, what will the result of that vote be? Will it have no effect on this?
You don't answer. You want me at the podium, or where would you like me to be?
Come on.
Chairman.
Oh, you might as well come up and give your name and address, so we have it for the record.
John Schreier, my office address is 601 Terrace. Commissioner Larson, to answer your question, and without wanting to put myself into a box that I may be saying something slightly different in a potential lawsuit, I think what you would hear from the owners, the owner's lawyers, is that if the zone change is approved, and if that's a valid way to make a zone change, both of which are somewhat open questions, they will tell you that as a legal non-conforming use, that use has the right to continue. And
I would assume that.
And one of the legal non-conforming uses is the very thing that's in front of you today. I suspect the owners will also tell you that given what may or may not happen in November, they have a desire to be more aggressive on locking in their abilities to do industrial development. I-2 is permitted in an I-2 between now and November. So the particular use that's in front of you would be allowed even if the electorate decides to change this to waterfront marine, and if that's a valid way to change that zoning ordinance.
That's as good as answer as I expected. Thank you.
City attorney.
Terrible.
Well, I don't think it's a problem.
Well, I will point out that Chronicle published an article where they consulted with a professor from the law school who was formerly with the Michigan Municipal League and was a former municipal attorney who basically said the same thing, that there would be a legal argument that legally zoning is not subject to initiative, and that if the court did find that it was in favor of initiative, it would still be calling the question whether or not you could take away an existing use. In any event, I don't think it would be reasonable for us to get into the habit of delaying things for the sake of delaying things. I voted to table last time because I felt that there were some deficiencies in the site. I've heard from staff today that this meets the requirements, the minimum requirements to approve a site plan. Doesn't mean I have to like it. But again, this is not, there seems to be, I was going to wait till after this. So why don't we, I'll stop. There's something I want to say when we're done with this issue. I know we have another item, we have the form case zoning things that I'm sure people want to talk about, because we've had that material for a while now. So I'll stop. Thank you.
I just want to get that one question I asked earlier. And as this letter seems to go with this, my concerns about tacit approval for development of that spit being, in one part it says no, that it's not, in another part it said they have the right. Did you?
That's their.
I know, it's their letter to us. I understand that. But does the letter go with this? Is this is this to assume that we are dealing with a scrapyard, which it says here, but the scrapyard is around this spit of water, and they imply they have the right to do what they want with it.
I don't believe they've ever given up the right to use shipping, whether they're shipping things in or out. I mean, that has historically been used as a shipping port.
So it says, this is all circled in, then that becomes part of the site plan that we're gonna go vote yea or nay on.
The port?
This
It's the inlet.
inlet, spit, inlet,
Yeah.
all right.
Commissioners done? Did Mr. Schreier leave?
No.
Just so I don't make an error here, Mr. Schreier, I believe we have a couple of options that we can do. Nobody votes to take this off the table. We can leave it on the table. We can express our specific concerns to staff and have them work with Mr. Melching. Or we can take it off the table, allow for the discussion from the Melching group and the audience, and we can convey the things that we feel that we need, and at that time conditionally approve. Those things are met, or give full approval, or table again until those conditions are met. Am I correct in all of that?
I'm looking for the exact language in the zoning ordinance, I'm not finding it quickly, but essentially, it requires you to either approve a site plan, reject a site plan, if you reject, then articulate the reasons for the rejection. Or third, conditionally approve. I would not take great issuance with a body last meeting who said we need more information, and so tabled it. I think you're now getting to the point of, I don't think you're going to get any more information. That additional tabling is going to be very productive. And I think what you will find, I think the Melching group will say, if asked, is we want a decision one way or the other. I would also point out for you that the standards for the site plan review are articulated starting on page 191 of the zoning ordinance, and so any rejection, frankly, needs to be triggered off of those criteria for the site plan review.
So commissioners, do we want to take this off the table?
I'd make a motion to take this item off the table for consideration.
Is there a second?
Second.
Moved and seconded to take the motion off the table and deal with it. Roll call, please.
Spataro,
Yes.
Masade,
Yes.
Larson,
No.
Mikesell,
Yes.
Mahalski,
No.
Parker,
Yes.
Motion passes. All right. Commissioners, do you have any further questions of staff before I, Melching Group? Okay. Representative from Melching, want to speak to this? Please come to the podium. Give us your name and address. Thank you, state.
We appreciate the opportunity to address this with you. I'm Ron Bolsche. I'm an attorney with the law firm Scope Fans, with offices in Brandon and Holland here on behalf of Melching. Mr. Johnson, Bill Johnson is here with me as well, many of you know him. I was not here with you last month, but I did hear reports of the meeting. We have heard the message about the request for a master plan, about the request for a PUD. We're not objecting to that. It is just premature. We can give you a site plan for the entire site. We can do it in a couple of different ways. We can put scrap metal processing over the entire site. We can put scrap metal processing where we think it's actually going to occur, and put the rest of it will be future industrial development. That's as much as we can tell you. As has been articulated, your zoning ordinance does not require that we are disallowed from using our property until we have uses for 119 acres. If that's what your zoning ordinance, if that's what you intend, you need to say that in your zoning ordinance. You don't say that our plan, our site plan application complies with your zoning ordinance. We are in favor of a master plan. We are in favor of a PUD, which will address all of your questions. We just don't have all the information right now. We are asking for a use which is permitted by right in the industrial district. We are asking for all accessory uses that accompany that use, and that would include the use of the shipping port. Again, that is by using your I-2 language combined with your I-1 language, and we are asking for the rights that we have as a property owner. I'm going to cut through a fair amount of what I would have otherwise said because a lot of it has been addressed. Mr. Schreier has adequately pointed out to you the standards in your zoning ordinance which need to be used when you make a decision. We are aware of the petition that's been filed. We are aware that the city clerk's been instructed to have that petition placed on the ballot in November. Our position is that a vote of the people cannot effectively rezone property in this city or in any other city. The Michigan Supreme Court clearly stated in a City of Livonia case that the initiatory process is precluded and superseded by the Zoning Enabling Act process. Land doesn't get rezoned in a city in this state without going through a planning commission public hearing, a recommendation to the legislative body, a decision by the legislative body. That's the process. Doesn't include a vote of the people. So we don't believe that any vote of the people will have any impact at all on our zoning. And as we stated, even if there was a way to rezone the property, and even if it was rezoned by a vote of the people in November, I can hardly think of facts that are more susceptible to a grandfathered non-conforming use than 100 years of heavy industrial use on 119 acres. We're there, we've been there, we're allowed to continue to be there. The demolition activities that are occurring on the property are not a land use. That's not what we're allowed to do under your zoning ordinance. We're permitted to do the demolition, but that's not the land use that we're allowed. We're allowed the land uses in the I-2 district. If we can't use the property for the permitted uses in the I-2 district, then my question to you is, what can we use the property for? If we're not allowed to use the property as it's zoned, then in our position, in our minds, the federal cases are clear, the state cases are clear, the Michigan Constitution is clear, and the U.S. Constitution is clear. The land use can't be taken away from us, even on a temporary basis, without due process of law and without adequate compensation. Melching stepped up, took the risk by the property, took the responsibility to clean up the property, but Melching can't sit by and allow its property rights to be taken away. Melching is only asking for the property rights that apply to every other property owner in this city, but we're asking for no less as well. It's a simple site plan. Mr. Larson has very adequately pointed out